Criminal procedure students, I am recording a new class and exam success video this spring 2026 semester. The reason that I am doing this is to include some coverage of the next Gen Bar exam, which Louisiana has not adopted, but I want you to be prepared in the event Louisiana does adopt it, or if you should happen to decide that you're going to take a bar in the state that does test next gen. So that's the reason for the new video. Little else has changed. So if you happen to have the prior video, I want to make it clear that that video is still correct and it's still valid. So this video is only to add another dimension to the conversation. And I want to be sure that I start making it clear what the purpose of this video is. So I'm going to begin by sharing the screen. And if you take a look at what's on the screen, it gives you an outline of what it is that we're going to talk about today. So when you leave here today, and you know I'm always encouraging you to ask your professor or speaker, what is the point of the lecture, so that you walk away at the end of the lecture understanding what it is that you were supposed to understand. So the first thing we're going to cover is exactly how it is that one might achieve an A in this class, or how one might learn to be successful in law school in general. The second thing that we're going to talk about is specifically success when you take the exam in this class, or success when you take the state bar, because they're both the same level of knowledge and expertise that you're going to have. And lastly, we're going to take a peek at the next Gen Bar exam, which again, I reiterate, Louisiana has not adopted. But I do want you to understand this bar for a few reasons. So let's begin with the question of how it is that you might be successful in criminal procedure as taught by Professor Bell, but just in general in law school. So what you're looking at on the screen now is an excerpt of my syllabus. And on the syllabus, I addressed this question. And the reason I started putting this on the syllabus is because students would enroll and they would always say, is it possible to get an A out of this class? What is it that I have to do in order to get an A out of this class? And I started then tailoring the syllabus to respond to that. So one of the things that I hope to accomplish in this video is to help you understand, first and foremost, that I have no opposition to 100% of my students earning an A in this class. So if everyone gets an A, that is the grade that I assign. So that is the first thing I want you to know, that I don't want to see people not get an A. The second thing I want you to know is that you will be well prepared to get the A in this class, but you will also be well prepared to pass the bar. So everything that we talk about in this video is both about success in law school, success in this class, as well as success on the bar. So the first thing to understand is that this class and most of your law school classes are going to require that you participate. Now, I want to start by telling you that participation in a law school setting can mean several things. Participating can mean that I am verbally expressing thoughts and contributing to a discussion verbally. But participation does not always mean verbal participation in law school. Sometimes it means I'm participating by actively listening. I'm actively engaged in listening. That is a form of participation. What I am asking you is to always be asking yourself these questions that you see on the screen. In other words, always police yourself as a law student and ask truthfully, was I just sitting in class, or was I really there participating? Now that we know participating means that I might be verbally expressing myself, participating might be that I'm asking questions, participating might be that I'm just actively listening and note taking as others raise points that maybe I didn't even think about. Always ask yourself, was I doing that, or was I just there? If you know that you are just there, you are not working toward an A in the class, you're not working toward being successful on the bar, you're not working toward being good in the profession. Engagement. Did you prepare before you came? How do you prepare before you come? Because if you're just doing a cursory reading, you are not preparing in this class, and that would be true of most of your law school classes. When I am in class and I am participating, do I come believing that I am the one and only person on the face of the earth? In other words, do I live on an island where there is a population of one, meaning no one else has an opinion that matters, meaning no one has an experience that matters? Am I open as we have discussions to thoughts that might impact other people in ways that I am not familiar? That makes me a much more well-rounded lawyer, that I can understand the way other people live, not just the way I live, or the way other people experience life, not just the way I experience life. Um, Contribution to the class environment. Am I making it clear to the class environment that I am not getting what I need? Am I making it clear that I have needs that I want to be met? In other words, maybe the professor is teaching in the way the professor feels comfortable, but that way is not in any way assisting you in your learning experience. Am I making that known? And the best way to do that, of course, is to email the professor privately and express the needs that you feel you have that are not being addressed, or it is to set up an office visit to have a conversation like that. And sometimes the way to get that corrected is that professor privately will start sending you things in a way that maybe you and only you need to learn, or that professor might change the approach to lecturing so that the entire class gets an experience that would involve the one that you need as well. So in other words, some people are, more active learners. Some people are passive learners. Some people might need to have questions called to them impromptu, and them being asked on the spot to answer. That keeps some people in the mode of always preparing and preparing well. For other people, that creates anxiety and trauma responses because they don't feel comfortable. So if a professor does not know, a professor cannot address or accommodate. And so my point is simply, if the learning environment is not conducive to the way you learn, that professor should be talked to about that and allowed the opportunity to afford you the experience that you need in order to be successful. I always also remind people that when you enrolled at Southern University Law Center, you enrolled at a law school that has a very specific mission and a very specific vision, both of which I have provided for you on the syllabus. When we are having class, when I am assigning material, I am always doing that with fidelity to the mission and vision of the Law Center. So remember when we talk that these conversations are not abstract. They're very much connected to the mission and vision of the Law Center. And when you read and when you do your critical thinking, it should be done in that way. Self-responsibility is a really big component of academic success. I'm asking you to ask yourself, um, when I do what I'm being asked to do, am I engaging fully? In other words, had I not been in the room, would anybody have been disadvantaged? Do I serve a purpose? Am I just showing up and in no way enhancing the environment? I am asking you to understand that the environment that you want for your academic success involves you making a contribution. So I am pointing out on my syllabus that as you think about what I need to do to be successful in class, one of the things that you want to think about in advance is participating in class, remembering that you can't be successful participating if you didn't prepare. So that is one of the first things that I want to talk to you about when you ask the question about being successful. The next thing that I'm asking you to think about is when you say, I really want an A, or when you say, I really want to pass the ball on the first attempt, the syllabus also addresses that. The syllabus says to you that in addition to preparing, which we just thoroughly covered, you have other things that you must do every single day if you really do want to be successful in criminal procedure, if you really want to be successful in law school, and if you really want to be successful on the bar. So take a look at these things. You want to always remember that dates on cases, dates on legislation, they are always a clue. So when you are reading and preparing for class, you are always watching dates. Dates will tell you what was going on in the country socially or politically. Dates will tell you based on that the kind of pressures that the legislature or the Supreme Court or even the executive branch might have been experiencing. So a lot of times you hear me say in class that what's important about the assignment is what is not written. What's important about the assignment is not going to be printed. And when I say that, what I am saying to you is that I may give you a case that is dated 1942. If you read the case and you come back ready to give me the holding or the facts and the analysis even, but you don't see the holding or the facts or the analysis wedded to what was going on in the country in 1942, you have missed a significant part of the case that is often unwritten. So what I am telling you is to prepare for my classes, you have to also be great as a historian. You also have to be slow enough in your preparation that you have time to really think about what you read and also put it in its historical context. So always anticipate me asking what was happening in the country at this particular time when this law was written or when this thing policy happened. Also, notice that I don't just say read what I assign. I say critically read what I assign. The word critical is very intentionally inserted here because what I am saying to you is if you read in the sense that I need to finish an assignment, that is not the kind of reading that is going to help you be prepared. Critically meaning reading, meaning I'm stepping back from what I just read and asking, what does this have to do with the topic that it falls under on the syllabus? So if it is under Eighth Amendment cruel and unusual, when then you read that case, I am asking you to question why is it under the Eighth Amendment cruel and unusual section on the syllabus. I'm asking you to think about what lessons does this case teach me about cruel and unusual beyond what the holding may say. I'm asking you to also think about if a different set of facts appeared on your exam with the law that you just learned, what kind of analysis might you do? I'm asking you to think as you read critically if that court voted that way, if one of the members are no longer on the court and a different member showed up and broke the majority, what would this outcome look like then? I'm asking you, when I say critically, to think about when you have a policy that is going to flow from this particular case, how it is going to impact people. In other words, are they unintended consequences to these cases? So if you're processing right now, you're realizing that it is impossible to adequately prepare for this class and do it in a rush, because this is a lot of mental work that you have to do before you get to the actual typing or writing of what you think happens to be legally valuable about the case. I'm also saying to you, if you want to be successful, never miss classes, particularly in criminal procedure, because of the way I teach. It's through a lot of examples. It's through a lot of things that are not really recorded anywhere. So if you're missing, you're often missing lessons that just can't be replicated. I'm also asking you to be a good note taker during class. You shouldn't be writing everything I say, because that means that you really haven't read or prepared on your own. You should already have arrived with everything I'm saying mastered in terms of the law, The challenge is understanding how to apply it. The challenge is understanding nuances, and that's the purpose that I serve in class. So when you're writing notes in class, it shouldn't be writing, this is the rules, because you should have read that before you came, is my point. Now, the outline. I know there is an industry in law schools where people will walk up to you and say, hey, I got an old outline from somebody else. Would you like to have it? I want to discourage you from relying on other people's outlines. And I want to explain to you why I am saying that. So when I was in law school, I used to prepare before class by reading everything I was assigned. Then after I read, I used to make a rough outline that explained what I thought I just mastered. Then I would get to class thinking that I had done the right thing and quickly realized that I was wasting time because a lot of what I put in that outline was wrong or it was incomplete. So what I learned is that there's another approach that works better, which is reading everything before class. If you're going to type case briefs or write case briefs, have them written before class. Do not attempt to put anything in the outline before class. So all of your reading and briefing is only for you to be able to participate in class discussions. After the class is when the outlining begins. So after the class, you have the brief in front of you, and the professor has just said, of all the things that this court teaches us, these are the things that you really need to remember for an exam. When you start hearing that at the bottom of that brief, you should be checking off what you need to put in the outline or writing things that you might have missed that you now know based on that lecture is very necessary for your outline. And then you go after class and your outline after class. So real success in law school is going to look like preparing before class by reading what is assigned, briefing cases that have been assigned, going to class and participating. So that is step 2 of 3. And then step 3 of 3 is then leaving class, troubleshooting what it is that you should have mastered, making sure that your notes from class reflect things that you didn't master well in your reading, and then incorporating now into the outline the things that class taught you happen to be valuable about your reading. So it's a 3-step dance, always preparing before, always participating during, always outlining after. And if you do this, you will never, ever have free time. So if I ever see students and they're sitting around in the hall with a phone and playing, on breaks, that is almost a confession that I am not really in doing the kind of preparation I need to do for academic success. Because if you're doing this, you never have free time. You're always working unless you're very intentional about saying, I need a break, which, by the way, I do encourage. I think your physical health and your mental health requires that you periodically carve out breaks. And sometimes that means saying that I'm not going to get to today's list because I physically need to take a pause. And that is permissible even in law school. Now, next thing you see is, in order to be successful, writing an essay is something that you perfect over the course of 3 years. You don't just show up on an exam and do that and do it well the first time. That is also true of multiple choice questions. You don't just show up on an exam and do that well the first time. So a part of your preparation is practicing multiple choice, practicing how to write essays, having the TAs check them until you feel confident enough to have your professor then meet with you to go over those sample writing submissions, or just to go over substantive issues that you think you didn't get. Also remember, as future legal professionals, we do not want to just be barred. We want to be employed. And most importantly, we want to be employable. So one of the things that I want you to understand for employment purposes is, if you go into a workspace and you have a supervisor, they do not want you to constantly come and ask them every single thing that you have to figure out throughout the day. every day in the legal setting is going to involve decision making, questions that have to be answered at least 60 to 80 times a day. If your supervisor has hired you and you're in there 60 to 80 times a day, they feel they can't get their work done. They start to view you as a liability. So part of the way I train my students is not to come to me with the question, the same way you shouldn't go to your supervisor with every question. The first thing you should do is begin to consult resources. So I put several of the most reliable ones on your syllabus. So if you have a question, for example, you've read the Fourth Amendment cases, you've come to class and you've heard the Fourth Amendment lecture, you still feel like there's some gray areas. My advice is go get the Hornbook first. The site to that is on your syllabus. Read that and see if it clears up the gray areas. The Hornbook is like one of the best translators in this subject. And if it does, you move on because you have many things to do. If it does not, and you try the practice questions that you've been assigned, then you say it's time for me to make an appointment with my professor. And I do want to make it clear, I encourage that. I welcome that. But I do not want you, whether it be this class or any other class in law school, to believe a professor is your study partner. To believe a professor is where you go every single day to ask all of your questions, because ultimately a part of your training is for you to be groomed into learning how to be not just a student, but a practitioner, how to be not just a student, but a professional, someone who can take the unknown and figure out the unknown. That's what law is. I don't always have an answer, but I have the skills that I developed over the years to be able to take a question that I don't have an answer to and find myself in a position where I have an answer now I'm offering up. You're not lawyers. I realize that it's not something you're going to do with ease, but I am trying to explain to you there's a process to getting there. So you cannot skip the steps. You have to learn how to troubleshoot problems on your own first. And then after you've tried, then you go and you seek out help or affirm that what you thought is the solution actually is. So with all of that said, there's a couple of terms that I need you to think about. And we're still talking about class success, law school success, practical success as a lawyer. The two terms that I want you to know, first is metacognition. It's a really big word. It sounds fancy, but it's quite simple. It's only saying learning how you learn. Metacognition simply means that every learner has a way that they learn, and it is very customized to each learner. So there are some students that will sit in class, that will listen, and all they need in order to succeed is just that exchange of information. So they learn by listening. There are other students that can sit in that same class, listen to the same lecture, and they need to go and get the code. They need to write the code into their outline. They need to get a whiteboard. They need to write elements out before they learn. There's some students that never can learn until they see a visual. So they have to do charts and diagrams and images. All of those learning styles are completely fine. There's nothing wrong with one. There's not another better than the other one before. The point of metacognition is for you to be successful in the way that I've described. The first thing that you must do is know how I learn. So don't make a mistake of trying to get a study group and study with the study group if that's not how you learn. Don't make a mistake of trying to study alone in your apartment in total silence if that's not how you learn. So the metacognition piece of this is that you can't do any of what I've asked you well if you don't know how to get started and be successful in learning. The second thing that I introduce all of my students to is something called Bloom's taxonomy. Bloom's is a system that basically helps us recognize human cognition. All of that sounds fancy, but let's reduce this down to what it really is. Bloom's is what you're looking at on the screen. And we start at the bottom, which is the purple box. And we learn that cognition, the mind, the processing of information, the learning, That happens in different stages. So when you are in that elementary school setting, when you're in the preschool classroom, the goal there is that you remember things. For example, I show you this ball and you remember that this object that is round is a ball. That is the goal of your preschool, elementary school years, where you're defining and memorizing and duplicating. You leave there and you are to be tasked now with doing something a little bit more challenging by the time you get to middle school, which is I'm understanding things now. I'm able to explain things. I can identify. Okay. So when you're in the preschool class at the remembering stage, your professor is not going to expect you to understand. But when you're at the middle school stage, your professor is not going to accept you trying to remember. So the point here is that as you climb these steps, as you evolve, your thinking is supposed to evolve. The cognitive skills are supposed to evolve. So when you get to college or high school, you should be in this applying box where now I can problem solve. Now I can actually operate by solving some problems. That is where you should be in college. What I want you to see from this illustration is that success in the practice of law, success on the bar requires you to be operating at these three boxes at the top. So many students come to law school and they are operating at the three bottom boxes. They remember, they understand, they apply, but they cannot analyze. They cannot evaluate. They do not know how to create a result from a set of facts. That means that if you're in law school trying to do what was successful in college, in high school, in elementary school, at preschool, you're going to earn those kind of grades. So, in other words, if I'm in law school and my professor's grading me on being a creator, but I'm down here remembering, I don't get the A that I used to get in preschool for remembering. Preschool, you got an A for remembering. Law school, you get an F for remembering. So what you have to now understand is that A's in law school, they're really tied to these three top boxes. And the bar is tied to these three top boxes. And being successful as a lawyer is about you mastering these three top boxes. So what's in those three top boxes? Evaluating. Now I can actually see both sides of an issue. I can defend one side. I can critique the other side. I can make some judgments about what likely could happen with a new set of facts or with the new panel making decisions. I am also now expected to create, which is now you walk in the door with a problem that no one has ever thought about before. For example, AI is this new thing, but now somebody has to come up with solutions to what happens when AI does all of these various things. That is the creating box that we're asking future lawyers to operate in. So Bloom's for me as a law student, unfortunately, by the way, I didn't learn Bloom's until after I left law school. No one explained success in these terms when I was in law school, which is why I started doing this as a legal writing professor, because I really got here to law school thinking that if I can remember and apply, I should get A's. But that did not do it. And then I started being told that you need to do a good analysis, but then I didn't know how that looked. So that is what inspired the work that I do, because when I started teaching legal writing, I started thinking about everything that happened in law school that prevented me from being successful. Now, law school is not supposed to work like that. It's supposed to make you successful. But there were things that happened in law school that said this is what we expect. The expectations were clear. The examples were absent. So if you tell me I expect a great analysis, but you don't show me how to do it. I was a first generation lawyer. I didn't even know how to ask anybody for a great example of an analysis. I didn't even know the significance of asking those questions. So what I am trying to do now is explain to you the I wish I had known. I wish I would have understood things that I had ultimately learned over the course of 3 years and many years after. I'm trying to spare you of that. So when I am grading papers or when I'm talking a lot of times in class, I'll ask a question and then I'll respond to you by saying, could you please get off of the bottom of Bloom's? I want you to understand what I am saying is that you're remembering what you read. That's not why you're in law school classes. Or you're understanding what you read. That is not why you're in law school classes. The other thing about this that you are to know is when I ask you questions, guess what? I'm not going to ask you to understand or remember. I'm going to ask you to evaluate or create. So the kinds of questions I ask you are going to come from these top three boxes, which means that as you prepare for my class, as you prepare for any class in law school, and as you prepare for the bar, don't allow yourself to accept that I remember and I understand and I can apply. Force yourself to analyze, evaluate, and create. And how do you do this? Because most law students, they do not arrive at the top three boxes. And because I love different visuals, I'm going to show you this explained a second way. The second illustration, again, it's the same as the first, just said in different terms. But what I want you to understand is that I am going to ask you to realize that every single student has to ask this initial question, and they have to do it honestly. Where am I on this taxonomy? Where am I? Am I at the understand stage? If you are at the understand stage, immediately tell yourself that on an exam, that is a D or an F. Now, I believe that you don't want a D or an F. I believe you want an A. So you now have to tell yourself, for me to get the A, I have to climb these steps to where I can create and evaluate. So the journey of law school, the 3 years that you're in law school, it is intended to help you get up those steps. Very rarely does a student come to law school at the green, blue, or purple step. Most law students are somewhere around that orange or yellow step. And the point of law school is to get you up the steps. So you should not be at the end where you started in the beginning. You should not at any point in law school accept being at any step except the create step. So always remind yourself that every single day is about getting up these steps. What do you do to get up those steps? One is you are constantly reading. You're not just reading the majority opinion, you're reading the dissent, because oftentimes the majority will give you a narrative. The dissent will give you the counter narrative. So it allows you with the same set of facts to see both sides. That does a wonderful thing for helping you learn how to be a critical thinker. You want to watch book TV on C-SPAN, listening to authors, some legal, some non-legal, defend their work. Show you how they design, notice the word design in that top box, solutions to problems. Notice how they revise structures that needed to be revised. So we're going to be doing a lot of listening to speakers, which you have an advantage now that I didn't have in law school, because you have YouTube, you have podcasts, and a lot of this stuff is done for free. You have listservs. That's something that is a really big deal. So I encourage you to sign up for any listserv that is relevant to your interests. So let's say right now you know that I'm really passionate about environmental law. So I would want to sign up for anything that gives me newsletter releases or listserv communications about environmental law. Well, what does that do? Well, one, if there's an important case, they're going to tell you. If there's a speaker that's coming to the area, they're going to tell you. Or if there's some type of class or workshop, they're going to tell you. As much as you're in the room with people who are high functioning cognitive thinkers, the better shot it is that you will improve your cognitive thinking skills. Also, when you're in class, if your class is just asking you to remember, understand, apply, class is a disservice. Class should be asking you to analyze, evaluate, create. So you'll notice if you're in my class, I will normally say to you the first day, don't ever expect me to ask you the facts or the holding, because I'm going to give you that. You don't need me to help with facts or holding. Where you need my help is the analyze, evaluate, create. And so most of the discussions we have in my class are getting you to that analyze, evaluate, create, which will then help you on the bar. The other thing that I tend to do a lot of is I'll ask you when you answer a question, would you not give me just your conclusion? I will say to you, I would like your analysis first. I'd like you to then give me a conclusion after. The reason for that is to get you in the routine of always seeing the analysis before you state the conclusion. That becomes important on exams because, as you see in a minute, when you write, the analysis has to come before the conclusion. Or for some students, you just need to have an analysis because many of them will give just a conclusion. So me verbally training you to always think in terms of no conclusion without an analysis, no conclusion before an analysis. That's a routine way that you'll be asked to answer questions. And if you have a professor that's not asking you to do that, just as an act of discipline, start doing it yourself. State the analysis, follow up with a conclusion. So that will give you the discipline you need on an exam to simply translate practice into action. All right. So now we've talked about the first part of today, which is how should I pursue the path of success in law school and in criminal procedure? That now I hope you have answers to. The second part of this video is now exclusively looking at not just the Louisiana bar exam, but the Louisiana bar exam as relates to criminal procedure. So there's three preliminary concerns. Like before you even get to the bar, there's three things you need to know in Louisiana. First thing, for criminal procedure, I have no way of knowing what the future holds. So everything I am saying to you is just based on my study of the last 20 something years of bar exams. It's predictions only. The predictions are that this subject matter will likely be tested through a combination of essay questions and multiple choice. You should know that the criminal procedure exam is attached to the evidence and criminal law exam. So this is a part of an exam that tests three different subjects. I am not in this video discussing evidence. I'm not in this video discussing criminal law. I am only talking to you about criminal procedure. Again, that part of the exam will ask you some multiple choice questions and some essay questions. So that means to prepare for this exam, you need to be proficient at taking multiple choice questions, and you need to understand how to formulate an essay response to a criminal procedure question. Both skills we will address on this video. Let's look at the prompts. The prompts, how do they ask you the questions on this section of the bar exam when they're testing essays? So I literally just cut and paste 1 year's worth of prompts. And guess what? These prompts are very consistent. What you're seeing on the screen, they're very consistent with the way this always appears. So watch what the bar says. The bar tells you that these questions are not weighted equally. So the first thing that I advise you to do on the bar or on your final is pay attention to the weight of questions. If you notice, this first question is worth 15 points. The second question is worth 15. This is only 10. Now, if you go and finish the 10-point question and you get nothing else accomplished, you just gave up 30 points. You cannot pass with 10 points. So what you want to think about is I want to go where the question is going to be worth the most in case I run out of time. The one that is worth the least, you don't want to run out of time. You don't want to not answer anything. But if it should happen, you do not want the question that you don't answer to be the one that was worth the most points. So Look at the prompts. It says, I'm asking you to respond to what the state and or the federal constitution says. So one of the mistakes a lot of law students will leave law school doing is thinking only about the federal constitution. Of course, you have constitutional law in law school. Most people don't think about it like this, but you actually have it twice. You have civil constitutional law, which is your constitutional law class, but then you have criminal constitutional law, which is criminal procedure. Most people rely strictly on the federal constitution throughout the whole 3 years of law school. They never even look at the state constitution. But I am pointing out that this exam tells you that you're already in trouble if you walk into criminal procedure on the bar and you don't know what the state constitution says about these criminal codes. So as I cover this subject matter, I teach the federal provisions, and then I also teach the state provisions. Make sure that you realize on these essays, you do not just default to telling what the federal constitution says. You also address Louisiana, even if it is to say that the state is consistent with the feds, which it is in many of these instances. All right. That's not all they're asking you, though. Look at the way they ask the question. May Jim reasonably challenge the search of his car? This is not only a search question because there's an and seizure. So we know now that in order to successfully respond to this, we are going to answer not one question, but two. Now, don't be confused because this is question 2.1, not question 2.1 and 2.2. So this is not two questions. This is one question, but they're asking you to answer two different things. In other words, you're doing two different analyses. You're doing a search analysis and a seizure analysis. Then they still are not done. They ask you, after you've done the analysis, what arguments might the state make? That's a third question, all in the same question. Then they're saying, is Jim likely to succeed? So in one question, you've been asked to answer four things. And one of the things that you're going to learn in the second is every single issue requires its own CRA, conclusion rule analysis. So to answer this question, you'd have to do a search CRA. You'd have to do a seizure CRA. At the end of the search CRA, you'd have to think about any arguments and raise them. At the end of the seizure CRA, you'd have to introduce arguments and resolve them. And then you would have to make sure as you write your C that you would write it to answer this question. Is Jim likely to succeed? This is the second question. Notice again, not just federal, but both the state and the federal. Now we're not talking about Jim anymore. We're talking about Tony. And guess what? We're going to ask you to do the same thing we just asked you to do, but this time it is about Tony. What about the search of Tony? That's one CRA. What about the seizure of Tony? That's one CRA. The arguments under search law for Tony, that goes at the end of your analysis for Tony. Same thing with seizure. The arguments for seizure, they go at the end of your analysis for Tony. Is Tony likely to succeed? That is the way your conclusion is going to be written. Third question for criminal procedure on the Louisiana bar asks you again, not just the federal constitution, but the state as well. Now we're asking about the statement that this guy is making while he's in the car on the way to the police station. They want to know if that statement is legal, the way that happened, and they want you to evaluate the likelihood of success. So this is going to be just one CRA, and you're going to tailor the conclusion to the call of this question. Very literally, I might add. Now, ultimately, what I just showed you was that question 2.1 involves Fourth Amendment. Question 2.2 involves Fourth Amendment. Question 2.3 involves Fifth Amendment. So the essays on this criminal procedure exam are essays that require you to be able to respond to a Fourth Amendment question and a Fifth Amendment question. I want to stress to you that this exam is representative of a consistent pattern relative to these essays. The essays are always asking Fourth and Fifth Amendment questions. All right. Third thing I want to say to you, very general overview information about the Louisiana bar. Again, I don't know what is going to be tested in the future. I am not making any type of guarantee about what is to come. I am simply telling you that I've studied many years of the Louisiana bar exam and noticed some patterns. The patterns for the Fourth Amendment is that it's often tested as an essay. Look at the screen. The pattern for the Fifth Amendment is that it's often tested for an essay. Look at the way multiple choice appears on this exam. The idea of forfeiture is a relatively new approach here. So that's one of the more recent changes that comes up as a multiple choice question. How do we institute a criminal proceeding? Jury trial rights, motions, post-conviction relief, which by the way, the law just changed on that. So you really need to be prepared for post-conviction questions under the new laws. Preliminary exam, multiple choice, right to counsel, speedy trial, time limits. In other words, is this case prescribed? Are you still able to prosecute me for that? Time limits are meaning how long do I have to file an appeal? Warrants, that is all through multiple choice. So what you're looking on the screen is a pretty reliable pattern of how subjects are going to come up as multiple choice questions versus essay questions. Now, I want to go to our next topic since we've covered now the general overview of the exam, some specific things to think about when it comes to multiple choice on the bar. And I also want to tell you this, when I write your final exam, I write it so that it closely parallels the bar, which means that your final for this class is going to be a combination of multiple choice and essays, just like the state bar is going to give you. Motions. This information that you see on your screen is actually on the syllabus for criminal procedure. So I'm not going to go through every motion. I just want to give you this assurance that some of these motions are tested through multiple choice questions on the Louisiana bar. I cover all of these motions in class. They're on your syllabus, so you will have thorough coverage coming out of this class about the motions you should be able to apply on Louisiana's bar exam. And I wanted to remind you that most of the times the motions are raised through multiple choice questions in Louisiana. So many students will come and say, well, Professor Bell, since I have to prepare for essay questions, how do I do that? Couple of things to know about these essays. These are not the essays like when you were in third grade where you could obviously eliminate 3 of the answers because they were just blatantly wrong. And then by default, you could figure out which one was right. That is not the kind of essay that you should anticipate on the state bar or any bar that you're going to take. The essays you should anticipate is that there's 3 really good answers, maybe 4. And you're reasoning your way to the one that is most precise. So in other words, they may be none of them wrong. They may be all correct, but there may be one that is more precise than the rest. Or there may be one that is blatantly wrong and 3 that are very close. You have to be able to understand the law well enough to pick out the one that is the most precise. So my recommended method of practicing multiple choice for the bar and for my final is through connected quizzing. So I just want to help you look at this if you've never seen it before. But when you go to the connected quizzing, this is the professor's view. So I'm not sure if yours looks 100% like mine, but ultimately you get to take this quiz. So after you take the quiz, and I have mine set up where you can take quizzes twice. So that means if you do it once and you fail, you go back, you look at every explanation for why you failed, and then you want to go take it again to see if you learn. That is set up like that. But I just want you to see how one question as an example of why I believe this is great practice for the multiple choice. So here's the question. A person is suspected of armed robbery. He is brought to the police station and placed in a lineup with 4 other men. They're all the same age, weight, and height. The only problem is the suspect is Asian American and all of the other men in the lineup are white. If this suspect challenges his identification, a court is more than likely going to do what? And you see that you have four options. If you choose D, you can click it and see if they'll explain to you why you're right or wrong. D happens to be the correct answer, so you have a check. If you had clicked B, B would come up with an X. But what I like about this is what comes after the answer. So look at the rationale. The correct answer is D, and then they give you the case. They explain why it is D. A, B, and C are all incorrect. Sometimes they'll give you why A, B, and C is all incorrect. But I am impressing upon you that I, every semester, say to my students, if you want to be prepared for the multiple choice section of this final exam and for the bar, use these connected quizzing questions for practice. Now, I have a way as a professor of looking to see when I assign this, who's doing the assignments. I have a way of seeing if somebody's doing them multiple times. I have a way of seeing it with their score. Would you believe, even though I've said to people, this is how I think you should best prepare for the multiple choice section of the bar, I would say 85% of the students they never even touch this. Or if they do touch it, out of the maybe 12 questions or assignments that I've given, they may try one or two, but they don't consistently do this. And we do have students who don't do well on board exams all over the nation simply because they don't have the skill to answer a multiple choice question. That is a choice, by the way, because you have the resources, but what the law center cannot do, or what a professor cannot do, is actually learn. There's nothing I can do to learn for you. I can give you resources. I can be creative in the classroom. I can give you some of the most dramatic, intense, amazing, unbelievable, mind-blowing lessons, but I cannot learn for you. And that becomes a challenge when a student is unwilling to learn for themselves. So understand that what I'm doing in this video is telling you that to approach the bar, to approach a final, you have to know how to deal with multiple choice questions. You also have to know how to do essay writing, which is where we're going next. All right. For Professor Bell's class, there is only one way to respond on an essay, and I'm showing you that. I'm going to increase the size, but for this illustration, I just want you to see there's three parts. There's a conclusion, there's a rule, and there's an analysis. And I'm going to talk to you specifically now about each of those separate parts. But notice line 1. CRA is the method that is required for my class. If you do not respond in CRA format, or if you do not respond as this format requires, your response is not read. That is how serious this is. There is comfort in knowing that when you take the bar, this method is the method that I encourage you to use on the bar. So you're not just doing this for my class. It is also a method that you could use universally if your professor does not tell you they have another way of writing that they want. Every time you get a new professor, you should ask that professor, do you have a preference of how I should write on essays? Let them tell you what they want and you give them what they want. But if they don't tell you, then you understand CRA is universal and it's a good approach for you to consider. Now, with the CRA method, I am saying to you that the C part, the conclusion part, it is going to show up first on the paper, but it should not be written first. You should never start with your C. So you simply leave room for the C and begin with the aura. So I'm going to skip C for a moment, come back to it. What happens with aura? I cannot stress enough that aura and A have a relationship. Aura and A have a relationship. So if aura is wrong, A is always going to be wrong. That is the importance of you processing what I am telling you. So let's talk about how aura works on this section of an exam. You want to remember that aura has to begin with the word under. That is non-negotiable. Under is a way of disciplining yourself to know that after I say the word under, I'm going to make a reference to the law. So some people will say under Louisiana Revised Statute 2310, under Louisiana criminal law, under the jurisprudence, under the United States Constitution. So you can do something very generic, something very specific, but this has to begin with under, and then you want to give elements. Elements are a requirement for this class, and I encourage you to do this in all of your classes. Now, if I say to my grader that I have 5 elements in rule, then that means when I get to A, analysis, I should at least be talking about 5 different things in my analysis. So that's why I'm saying there's a relationship. But right now, we're strictly focusing on how to present aura. It's going to start with an under. It requires elements that you could either list vertically, which is what you see on the screen. You can list horizontally, which is what you see on the screen. Or you could simply write your statement and underline elements, because some people don't like the idea of attaching numbers or writing vertically. So you have 3 ways that you can give the rule, but you need to follow one of those 3 ways. Now, I want to call your attention here to this language. Defenses and exceptions. This is arguments as well. All of that, if you have them, you can note in rule that there are defenses that apply. You can note that there are exceptions that apply, but you shouldn't be getting into a discussion of them in the rule. The rule is literally for you to give the law that's going to govern the scenario and a quick reference if there are any defenses or exceptions. Now, the analysis. I must stress that 95% of your points on your exam are going to come from analysis. Please, please master this skill immediately. Do not anticipate ever doing well on any exam or on any bar if you cannot perform a sound legal analysis. Now, I'm going to get emotional right now because last Friday night, I did bar review with students who said, I don't know how to set the rule up. I don't know how to write the analysis. And those students, after that bar review, have been sending me things that they're trying to learn now how to write and how to do rules. And none of that should be done at the end of a course. None of that should be done at the end of law school. And really, none of that writing part should be done at the end of your 1L year. So 1L year, you should know how to write. You should understand how to develop analysis. And year 2 and 3 is just expanding that information. Years 2 and 3 is about, of course, learning new law, more law as you go. But the writing and the analysis, that foundation should be set as a 1L. It is a very difficult place to be when you're sitting for a bar and you have to learn how to write. Because at that point, the bar is about substantive knowledge. It's about execution. It's about performance. It's not a place for you to have to be trying to figure out how to write or how to state a rule. Do not allow yourself to finish a class and not know the rules that you're going to have to apply on the bar. Do not allow yourself to journey through law school without knowing how to do an analysis. So you may say, well, how would I know? Well, how do you know comes from 2 ways. One, you have a professor like me that just sat here and said, I've pulled 20 years of exams. Here is the patterns that I'm seeing. So that professor has alerted you of what rules you need to learn. You have the responsibility of making sure that you're in class with that list and you're going through the list every lecture and saying, I'm checking off this content that this professor said is going to be on the bar. I'm checking off the coverage. I'm asking now to make sure before we leave this subject, how would I write this on the bar? So you don't have the right to sit back and expect your professor to just do all of that. You have a duty to be involved. When you draft an outline in law school, this is something I did. I never wrote an outline based 100% on what the course was going to cover. All of my outlines began with me, not my professor, me on Christmas break before I started school, looking at the old bar exams in that subject and trying to write out my list of issues that were going to be tested. As I went through class, I was constantly checking the outline that I'm getting from class against the outline that I wrote myself before the semester started. And if I did not see coverage of that, I was going into professors' offices saying, you've covered two things, but there's 13. I'm worried it's half the semester. Are we going to get to these other 13? How do I get to these other 13? So I also policed my professors. I'm in no way saying that you don't have capable professors and it requires that. I'm telling you, I was just that neurotic that I wanted to make sure that I was prepared. I was that student that I did not have anybody to help me. I was struggling to get help through the 3 years, and I knew that I could not afford to not pass. So I was policing the process as well as making sure that I got what I was supposed to get. But fortunately, I had professors who also were mindful of what I needed and who also talked to me about this along the way. So I'm letting you know that there's no excuse to say, well, the professor didn't. Well, it doesn't matter. I mean, this is your life. You need the coverage. You need to be responsible for planning before you take a class, for pull bar exams. Start your outline with a list of what you see is necessary, and then ask the professor if they're not being aggressive enough for you, or if they're not being deliberate enough or intentional enough with the time in class to make sure that all of those subjects are covered. Now, just like I said to you, rule starts with the word under. Analysis for me starts with a very specific word as well, and it is the word here. Here is a way of disciplining yourself to say, once I say here, I now need to start talking about the actual facts that I'm going to apply to the law. First thing that I'm asking you, if you take a look at the screen, you have to have a paragraph that clearly states the rule. When you get to analysis, it should not be blended with the rule paragraph. It has to be a separate paragraph. Now, if you learn this, you are guaranteed to succeed on an exam. What I teach is that analysis for me is only a formula. It is a repetitive formula. So I've highlighted what goes in the formula. There's three things. The formula is always going to end with a mini conclusion. And I all recommend indefinite language. So it is likely that this element is met. It appears this element is met. That's the mini conclusion. That's the end. The beginning is a topic sentence. Topic sentence simply says to the reader or the grader, this is the element that I'm discussing. And then between the topic sentence and the mini conclusion is your analysis. Analysis is my explanation for why I believe the element is met, or my explanation for why I believe the element is not met. Analysis is not based on my individual opinion. Analysis is based on law. So it is the way the cases tell me that I have a test that I apply when it comes to this element. And it's me applying the test as shown by those cases. It's the rules that the cases give us to say that if you want to determine if there's a seizure, for example, well, there's a definition of seizure. And there's a lot of cases that have taught us how to recognize a seizure. So my analysis is me doing that work of applying all of what I've learned through those cases. I am stressing to you, analysis for me is a formula. Topic sentence, your analysis, which is your linking, and then mini conclusion. And I'm going to demonstrate how that looks in a second. Now, most people say, I get the topic sentence, Professor Bell, I learned that, I got it. I get the mini conclusion, got it. Most people say what I don't get is the linking. I don't understand how to link. I don't understand how to look in the facts and find the facts that I'm going to connect with the law. And that's where most struggle in law school. So what I did as a legal writing professor is I was trying to help you see. So what I'm showing you on the screen is what happens mentally. This is not what you do on your exam paper. It is what happens mentally. Mentally, in the scenario, you think about the idea that on the left, that is my rule. Everything on the left is the rule. So this rule that we're looking at now has elements 1, 2, 3, 4, and 5. So this is a rule with 5 elements. The mental work that I am teaching you to do is, if you are going to talk to me about element 3 is dog. I am saying when you get to the linking portion of your analysis, you must go in the facts, which is all of this stuff on the right, and find the bone that goes with the dog and link the two together. Now, this is based on the way you've learned to match things in preschool. But in law, let's say the element is intent. So dog for a moment is no longer dog, it is intent. We are going to look through all of these facts and find something that suggests that this is intentional. So, for example, the person actually went through the phone book and found stores that sell guns. They called the stores to see the hours of operation. They asked the stores, what time do you open? What identification do I need to purchase a weapon? Do you sell this kind of weapon? Then they went to the store during those business hours with that type of information that was solicited, and they presented it, paid for it, got it in the vehicle at 2:30 in the day. They went home because they were tired. They knew that they would be up a long, long time that night, because not only did they have to kill a person, they had to bury a body. So they went home and took a nap. After the nap, they had a choice to make. Do I stay in my house and not commit this crime? Or do I go in my vehicle, drive to the crime scene where I'm going to kill somebody? They did all of the above. So your analysis is in explaining through all of these facts, which one of those facts give you a sense that this was intentional, this was premeditated, this was planned, this was not impulse. So you would have to say about the phone call to the gun shop. You would have to say about them arriving at the gun shop during working hours so they could make sure they got it, arriving with all the documents and the paperwork and the money they needed to make the purchase, having time after they left the gun shop to go home or do something else, but them making a promise to fulfill this act by getting in the car again at night, going to the place, intention again, driving very intentionally to the place, going and pulling out a gun. You could spray it all over the place, but I pointed instead directly at this person. All of those details tell me that this was not accident. So when I say to you, there's a formula, and I say to you that you have to, after giving me a topic sentence, do the analysis by linking the elements with the actual facts. What I just said to you is how it is done. Now, I hope that helps you conceptualize. I have a few final points before we get into looking at an example. I am reminding you that an examiner does not have a duty to read everything you write. The examiner doesn't have a duty to disclose what they want to read. So you must write as a customer service representative, making it very easy for that examiner to be able to find the pieces of the response they want to grade. So the way I would demonstrate this to my students when I taught legal writing is I would explain to them that a writer is to avoid writing gumbo. A writer intends to produce lasagna. What is the difference? Gumbo is this heaping pot where you just throw stuff wildly into the pot. So there's chicken, and there's crab meat, and there's onions and celery, and then there's meat, all kinds of sausage. There may be pieces of crab in there. Some people put ham in the gumbo. All of that's in the pot. For that examiner that says, I don't want to grade elements 1 through 3, I just want to grade 4. If you got a pot of gumbo, that examiner has to go in the pot and pull out 4, which is impossible. There's no way to get the chicken with nothing else on it. There's no way to get the sausage with nothing else on it. Everything in the gumbo pot is going to have a touch of something else on it. The sausage has gravy on it. The sausage has rice. The sausage has onions. So when you do lasagna, lasagna's layered. Lasagna's organized. So if I am deciding as I eat lasagna that I want to lift it up and I want to identify where the meat separates from the pasta and where the pasta separates from the cheese, I in fact can accomplish that. Psychologically, you have to remember what I just said as you write, because a good writer does not produce gumbo. How do we achieve lasagna? You'll see in a second the organization that I just spoke about. You'll see it done. But also remember that if you have multiple issues, and you just saw in the Louisiana bar, one question will ask multiple issues. Every issue needs to have a CRA. Take a look at what's here. Also, captions help an examiner tremendously. So for that example I gave you earlier where the question asked you to talk about seizure and search in the same question, you would begin by having the caption seizure, and then you do CRA. And then you'd have another caption that says not seizure but search, and then another CRA. When you're doing that legal analysis, remember that there are some words that are so important in law that you literally want to quote them, like probable cause in criminal procedure, like reasonable suspicion in criminal procedure, like Terry stop. Those are words that you need to drop. You need to do some name dropping on all of your exams. You have to know the names to drop, okay? How do you get that information? Because normally in lecture, your professor is going to say to you, like, this is a landmark case. This case changed the law. This is a case you need to say by name on your exam. Again, that is why going to class really does matter. Now, I want to also mention, what do you do if you need to talk about counter arguments or exceptions or defenses? Earlier, I said you can mention them in the rule, but now in the analysis, I'm telling you, this is where you do the analysis. So at the end of the elements, let's say there's 5, you've given me a discussion of 5 elements. You would then say after the 5th element, there are discussions that apply here. There are defenses that apply. Or you'd say there are counter arguments that apply. You state the argument, you state the defense, you state the exception, and then you do the analysis of it. And your analysis, of course, would be here's the rule that governs this exception. Here's how I apply that rule to these facts. Here's why the exception matters or why the exception doesn't matter. All of that is done at the end of your analysis of the rules. Now, remember, we're not done because we didn't give a conclusion. Remember, I said save the conclusion to last. So you go back at the top and you simply now say, I'm going to answer the question that was asked. This sounds so simple, but most of the students that I grade, they don't even get the full 2 points that I might give on a conclusion because they simply do not answer the question that is asked. So I encourage you to be as literal as possible when you answer the conclusion. So if the question said, what is the likelihood of Dan succeeding? Literally say, it is highly likely that Dan would succeed, or it is highly unlikely that Dan will succeed. So you want to literally track the language of the question as you respond to that question. All right. Now, I want to get into now you seeing a little bit of how this should look. I know everybody immediately, when you give them a model, people start taking screenshots. They frantically start writing. I'm going to ask you to discipline yourself not to do that for a moment because you can go back and play the video as much as you want. I'm just asking you right now just to look, just to look. I'm going to talk about the sections and the parts in a minute, but I just want you to look. And the reason I want you to look is because what you're seeing on the screen is a sample response. I highlighted the C section just so you could identify it and recognize how it should look, but I don't expect you to do that on an exam. I highlighted the R just so you could identify it and see it, and the same with the A. Cosmetically, though, I wanted you to notice this is not gumbo. This is lasagna. Lasagna because I can find every piece and part. I can see where one part stops and one ends. A couple other cosmetic things. Notice there is a blank line between C and R. Notice there's a blank line between R and A. Notice there's a blank line between each of the paragraphs in that discussion. And then I'm going to ask you in a second to notice the formula. All right. C, the warrant does not appear to be valid. So this question would have been, is the warrant valid? Literally answer the question. Some people stop there. Some people give a brief explanation. Either works. Notice the rule starts with under. Notice the rule gives elements either vertically, horizontally, or either horizontal and underline. Your choice. Point here. There's a relationship between R and A. Because aura tells me that I have 4 elements, I know when I start reading A, I'm going to likely have 4 elements. So here's element 1, probable cause. How do I know? Because of the topic sentence, which I underline to help you see. Element 2, oath or affirmation. How do I know? Because I underline the topic sentence. Element 3, particularity. I underline just so you could see. And element 4, was the warrant signed by a judge or magistrate? Now, next thing I wanted you to see, remember I told you earlier that there is a formula to be used in legal analysis. I'm just going to take the third element, particularity, to help us see how this formula is used. The formula I said to you earlier starts with the topic sentence, so I am going to highlight this topic sentence. I said to you earlier, the formula ends with a mini conclusion. So I'm going to highlight the mini conclusion. And then I said to you earlier, everything between the topic sentence and that mini conclusion is supposed to be us linking, or at least our legal analysis. So I'm shooting here for a different color so we can see what I call the highlighter method. This is why I tell students you really don't need an appointment to see your professors to have them review your writing initially because of the highlighter method. With the highlighter method, I recommend you have 3 different highlighters. And when you believe you've done a legal analysis, you highlight the mini conclusion, which is what you see in blue. The mini conclusion is your resolution of that element. It appears this element can't be met. That's mini conclusion. Then I say with a different color highlighter, highlight the topic sentence. Particularity must be considered next. So I'm saying to my reader, I am discussing the element called particularity. And then I say to the student, the third highlighter is supposed to be your linking, your analysis. Nothing else is allowed in the analysis as I teach it. Topic sentence first, mini conclusion last, linking in between. So let's take a look at what's said here in this green text. Particularity involves the specific notice that the warrant communicates. The warrant must disclose the exact place to be searched or seized, the persons to be searched or seized, the purpose, the reason for the search or seizure. Now, what that ultimately is me saying to my examiner that I am fully aware that legal analysis requires me to explain any term of art that I believe I am to use. If I do not explain the term of art, I am not doing my job. So under this law, particularity is a term of art, meaning it means something special. So the writer takes the first few minutes to explain that they know that. Now we're going to link. The application says that the search was for any dogs, meth, or other illegal drugs. And I have a quote here with all the stuff that you can search for. It is very specific as to the contraband to be seized. The application, however, was not incorporated into the warrant, nor was it signed by the magistrate. The portion of the warrant that calls for a description says yellow form and Folsom. The magistrate signed that and failed to include anything else that would have been particularized. and therefore it appears that we cannot satisfy this element of particularity. Remember, the trick here is to explain why I feel the element is or is not met. So I'm going to let you take a look at this first paragraph for a reason. First element is probable cause. I wanted you to see sometimes you cannot resolve an element in a single paragraph. Sometimes it takes multiple paragraphs, and that is what I'm having you see on the screen. So the first element, probable cause, is going to be resolved in multiple paragraphs, and there's a reason for that. Notice I said anytime there's a term of art, you have to tell the examiner that I know this is a term of art by explaining it. So I just did that. Probable cause exists when considering the totality of the circumstances a police officer would believe a criminal act occurred and the defendant committed the act. Now, I'm showing you how the definition involves two more parts of an analysis. So to answer this question, I have to answer, did a criminal act occur? Then I have to answer, did the defendant commit it? So everything that I'm doing from here on is an attempt now to apply that definition. It took a total of one paragraph, two paragraphs, three paragraphs to answer that probable cause question. So I wanted you to see that, just to see that for some of these elements, you cannot resolve them in a paragraph. So that is fine. And when I say R is an outline for A, I don't literally mean if R has 4 elements, A must have four paragraphs. I simply mean that you have to have a discussion of element A and an analysis of element A. You cannot just say A and don't do an analysis of it. And sometimes that analysis can be done in a paragraph. Sometimes it takes longer than a paragraph. So that is an illustration of a good response, the cosmetically good response and the substantively good response. You see organization, you see the magic words, under with rule, here with analysis. You see analysis simply following a formula from first element to the last. Topic sentence, linking, mini conclusion. Topic sentence, linking, mini conclusion. That's all we do here. Now, I wanted next to show you an old final exam that I gave. This is really from an old final exam. This question is worth 14 points. This is about a guy who shares a vehicle with his brother. And this guy and some friends decide that they're going to go to one of the state prisons and visit a craft fair. That craft fair is open to the public. When they arrive, they are given the notice that you see on the screen. The notice essentially says that it's a crime to bring contraband onto the facility. And if you enter, you're giving us consent to search your vehicle. Goes on to tell them that the things that could happen, what you can bring onto the grounds, what you cannot bring onto the grounds. All right. Then the exam basically says that they get into the facility, they park the car, they are starving. So they think they locked the car doors, but apparently they didn't. They run out, go get food, they come back, and they see an officer at the front hood of the car. The officer is putting inventory tags on things that was taken out of the car, and the officer decides that he's going to arrest Fox. Why? Because there was drugs in that vehicle. Now, this is a vehicle that Fox shares with his brother. Look at the question. Because I said to you earlier how many times students lose points for simply not answering the question. Fox feels his Fourth Amendment rights were violated when the search happened. Fox wants to know, did my Fourth Amendment rights get violated? Do you agree with him that his Fourth Amendment rights were violated? Listen to what I said. The question, do you agree with Fox in his belief that his Fourth Amendment rights were violated? So when you write your answer, you should be saying, I do not agree with Fox, or I do agree with Fox. But I want to show you the first paper. I'm going to give you 2 examples on this final exam. The first student got 0.75 points out of a possible 14 points. 0.75, so that's less than 1 point out of a possible 14 points. So this is an example of what not to do. Look how they answered the question. Fox's Fourth Amendment rights were violated if he was not in the driver's seat and not issued the document given notice. Okay. The question, do you believe that his rights were violated? I don't see, I believe, I don't believe. I notice that it's not Fox's, apostrophe S is Fox. And I know that there are, official publications that say the bar doesn't check for punctuation and grammar and spelling. But I would mention to you that a grader is like any other person. They can be biased. They can form opinions about a reader unintentionally. And so when you don't use proper grammar, proper punctuation, when you misspell, all of that communicates very subliminally a message to a grader about your competency. So I would just stress to you that you be mindful of all of that when you write responses. But then this particular student, after they talk about the Fourth Amendment issue, they go on to the if and all. If not, what that says to an examiner is that I really don't know. I really don't know how to answer the question. So I'm going to give you a whole bunch of scenarios and hoping that I land on the right one. For an examiner, that is not a good feeling to have when you think a person is trying to manipulate a way to get some points. When you think a person really doesn't know the answer, and instead of them not knowing, they try to figure out a way to make it look like they know. That's a bad strategy, and it doesn't get points. So this question wants to know, do you think a Fourth Amendment right violation exists? That's what you should be talking about, not about if they did, if they didn't. Answer what is asked. Next thing, you see aura is supposed to begin with the word under, so that's beautiful. Under the Fourth Amendment, they give a little law, and then they go on to say a search is presumed unconstitutional if there's no warrant. Then they said there's exceptions to the search. Then they said there's elements to the Fourth Amendment. Then they said there's elements to a warrant. Now, one thing that you should know is that 90% of what is here is not even needed to answer this question. So, what is the search? It's beautiful that you would want to talk about it, but you should not be talking about it here. You should simply summarize the Fourth Amendment law. You should give the elements. This person gave extra stuff, which is what I'm highlighting. Search, as you talk about that element, it's element two. This should be in the discussion of element two. It shouldn't be here. They also give the elements, and they only give three when there's actually four. And then they give me elements here that don't have nothing to do with the question. So slowly, but surely, this writer is telling the examiner that I really don't know what I'm doing. I'm saying it to you very subtly as I write the conclusion. I'm reinforcing now this conclusion that I have about you as a writer when I write the rule, because the rule is containing extra stuff that has nothing to do with this question that needs to be answered. Then we get to the elements. Remember, the analysis is supposed to start with the word here. Notice it's missing. So on an exam, I simply wouldn't grade anymore after this. When I don't see what I'm supposed to see, I'm not even going to grade. But let's assume I did grade. Look at the analysis of government actor. They start, remember, analysis is a formula. Topic sentence first, mini conclusion last, linking next. We first determine if the person who searched the car is a governmental actor. This is a great topic sentence, all right? Then the mini conclusion, the governmental actor element is met. Notice it's not indefinite. They use definite language. Remember the formula, everything between the topic sentence and the mini conclusion is supposed to be linking. So I'm going to highlight linking. Let's test that out. Linking is supposed to be you showing me what facts go with the element. The element here is governmental actor. Governmental actor is a person who is an authoritative figure that holds a title based on specific training and certificates. I applaud this writer because they do attempt to explain to us that they know a governmental actor is a term of art. Whenever you have a term of art on an exam, you do have to explain it and you have to apply it. So this is excellent that they decided that that needed to be done. The problem is that the definition they give is wrong. The way they define governmental actor, that can be the maintenance person. That could be the people who just picked up my garbage can a little while ago. Does not answer the question accurately. So the information is wrong. But let's see, where's the linking? This is what they attempt to call an analysis. The facts point out that facts saw Officer Jones and based on the title. This is usually enough to show that there's a governmental actor. This is classic poor writing. The person is telling me that I am linking facts, and actually they have done no linking whatsoever. The person is telling me that they're writing a legal analysis, but actually there is no analysis whatsoever in what I have just highlighted. No, I'm sorry, I did the wrong thing here. No analysis at all. This is completely just wasting the reader's time. Let me tell you what things make this bad. The facts point out is a huge problem in writing. When you say the facts point out, what you're saying to my examiner is, I have a bunch of facts that you wrote, by the way. You go figure out which facts apply. And what the examiner wants you to do is to say, I know how to go in the facts that you wrote and pull out the ones that have something to do with this element. So the facts point out is code for I don't know how to do legal analysis. The facts point out is code for I am going to trust that you'll do my work for me. That is a huge red flag and a guaranteed way to lose all of your points because you've done no linking. Remember, linking is I am getting a fact and I'm connecting it. I'm finding the bone and connecting it to the dog. I'm finding a second bone and connecting it to the dog. I'm connecting all of the bones to the dog until there are no more bones. Facts point out is one huge problem here. Based on the officer's title, this is enough. I don't know why you think that, but you're telling me it's enough. So the second problem is if you're going to use his title as the bone, I need to know why you decided the title was the bone. So explain why the fact shows you what you tell me it shows you. This is poor analysis. And I want to show you the comments that I gave this student on this paper. Look at my feedback. I said to them, you get 0 on the conclusion. Why did they get 0 on the conclusion? Well, you should know. I just went over that with you. Why? Because they had a conclusion. What did they do with the question? They didn't answer it. After they didn't answer it, they started volunteering, or I don't know, maybe so. They get 0 for that. The rule could have been up to 2 points. They got 0.25. Why? Because they didn't give me all the elements and they gave me a whole bunch of other stuff that shouldn't have been in the rule. Look at the analysis here. The analysis, this was a 14-point question. Conclusion was only worth 1 point. Rule was only worth 1 point or 2 points, I believe. So all of the rest of these points, almost 12 points, are devoted to analysis. Could not do anything here with analysis because everything they gave me was nothing but conclusion. So we have basically either substantively, I did know the law, which is for element 4. For elements 1, 2, and 3, I've given all conclusions, no analysis. So out of the 12 points that I could have earned, I've earned 0.5. I've lost 11.5 points simply due to no analysis. The analysis issue is a problem all throughout this paper, starting with the state actor. Look at all of this stuff. It's no analysis. So I want you to take your time, zoom in on this answer, and notice why this person, that's the most important thing. Why did they not get any points on here? And this has everything to do with you recognizing that the analysis is a formula. You cannot get the points if you don't know how to link. Now, this is the same class, same exam. I'm going to give you a few moments to read this one. I'm just going to give you a moment. I want you to read the exam paper. I'm going to give you a second. I'm going to let you look through it carefully. This is a student that got 13.5 out of 14 points. So take a moment and read. You should still be reading. Okay, now I'm going to go over my feedback that I provided to this student, but I want to point out a couple of things on this paper. Just step back and look before you do anything at how this is considered lasagna. Again, I don't expect the student to write the C, the R, or the A. That's there for you to be able to understand the parts. Notice the C literally answers the question, except look at my feedback 1.5 instead of 2 because you ignored the call of the question. I shouldn't say literally. I should have said did not literally answer the question. So they got the answer correct. The substance of it is right, but they did not write it to literally answer the question. Let's go back to the question to make sure you understand why I told that student what I just said. The question, where's the question? Here it is. Fox feels his Fourth Amendment rights were violated when police searched his vehicle without a warrant. He asks if you believe a Fourth Amendment violation occurred. Do you? Look at the question here. It appears Fox's Fourth Amendment rights were not violated when police searched his vehicle without a warrant. So this is substantively correct. The question says, do you agree with Fox? You see literally how you have to answer the question. Notice aura starts with under. Notice this aura has the correct elements. It's 4 elements, not 3. Notice A starts with here. Let's compare the analysis of this governmental actor versus the other, just to show you why this student performed better. A governmental actor is to be determined because the Constitution only applies where the government is acting. This is what we would consider a topic sentence. And remember, A is all a formula. It's nothing but a formula. So we got a topic sentence. Now, this person's A is actually 2 paragraphs, but look at the mini conclusion. It is likely that this officer is a governmental actor. So we see that we have a topic sentence and a mini conclusion. Now, everything between there is supposed to be the linking method. Remember, linking is I am telling you that I know that the dog is governmental actor. I'm looking for the bones to show me that they connect to governmental actor. So here's the bones. One must assess if the person works for the government and if the person's acting in the scope of their duties. That's me saying to my examiner that I know governmental actor is a term of art, so I have to explain it. Next, upon notice of Officer Jacob, he was found at the front of the vehicle. This is important because notice tells us that the person who's around the prison grounds inspecting these vehicles, they must be authorized to do what they do. And I know prisons are governmental entities. So if you're working for the government, you must be a governmental actor. But they said that's not enough because I'm not going to give you one bone. I'm going to give you all the bones. Look at what the guy is doing. The guy is placing inventory tags on items that he's seizing out of the vehicle. It turns out that this sign says if you bring in drugs, that's going to be considered contraband. He's enforcing the sign. That's another bone. So if you can see the difference now between this analysis and the other one, because I'm not telling the grader, you go look in the facts and figure it out. You go figure out why that man's a governmental actor. I'm actually telling you that I'm going to go in every fact and give you all the bones, and I'm going to tell you why I think he's a governmental actor. This level of development happens for every single one of these elements. That is the reason that this particular student performed as well as they did. Look at the comments. They got max points for every one of the analysis elements. and then ultimately near perfect score on the question. All right. That's a Fourth Amendment question on my final exam. This is from the same final exam, same set of facts, but this now is a Fifth Amendment question where now this guy who we found these drugs in his car is being taken to the police station. He's in the back of the car and he's just telling the officer stuff that is incriminating, by the way. The officer didn't ask any of that. So here's the question. Fox wants to know if his Fifth Amendment rights were violated when, without any Miranda warnings, he provided statements to the police on this ride to jail. Was that a violation of his Fifth Amendment rights? Here is a student that got half the points, 7.5 out of 14. I wanted you to see half. I wanted you to see a student that got more points. It appears Fox's Fifth Amendment rights were not violated because the statements made in that call were voluntary. Nobody was interrogating him. That's the not only an answer, but slight reasoning. Look at my feedback. Good, but you did not answer the question asked. Remember, literally respond to the words in the call of the question. The call of this question here says, Fox wants to know if his Fifth Amendment rights were violated. So your response is, it is likely they were violated. It is likely they were not. This is what you should be answering. And literally it says on here, Fox asked your legal advice. Specifically, he wants to know, what is your legal advice? So my legal advice to Fox is, my legal advice to Fox is not. That's what you're supposed to be establishing under your conclusion. That is not done. Notice the rule here. Remember I said that you could list your elements horizontally, which is what you've seen in the prior examples. You can list them vertically. You could also list them horizontally and just underline. This is an illustration of the horizontal listing, but the elements nonetheless. So this works. Notice that this rule starts with under. Notice the analysis starts with here. And you'll just notice that every one of these paragraphs, you have the formula followed. The student did a beautiful job of modeling what it is that they were asked to do. Topic sentence here, mini conclusion here, linking. Custody is a term of art, so I'm going to explain it. And then I'm going to do all of the bones that go with the dog custody. And that is done throughout. So I wanted you to see that student. Here is the issue, though, with this paper. Very important lesson here. You'll notice that this rubric does not have any points given for analysis of element 1 or analysis of element 2. This is really important because if you remember, we went over element 1, which is governmental actor, and the person did a beautiful job, but I wasn't grading governmental actor. So the reason I included this question is to help you see that the questions that I were trying to grade, A3, which is the element of interrogation, great definition, but downhill from there. You never did an analysis of the definition as required. This is all C, very incomplete, but great reasoning. Then look at A4, waiver element. When do these elements apply? Do they apply in this scenario? If not, why are they being discussed? Poor analysis. So I just showed you a student that did a marvelous analysis of element 1, but I was not grading element 1. Marvelous analysis of the other element that I wasn't grading. The point here is to show you how the examiner sometimes is looking to grade elements and you don't know which one they are, but it's not all of them. So that is why you want to write with lasagna to make it easy to follow, but also you want to write in such a way that you convince the examiner on every element that you know what is being asked, because they may not grade all of them and they don't have a duty to tell you that. Now I want you to see that this is another question here that I'm assigning. Somebody got all points, 14 possible points. This person, look at the feedback that they got. Conclusion, great. Analysis issue number 3, great. Analysis issue number 4, great. So this is a person, I'm going to focus just on 3 and 4 now. Let's look at 4. Lastly, we must analyze the actions of the accused. Although that is, by the way, the topic sentence. Although it is my belief that custodial interrogation never took place, it is important to analyze the actions of Fox because he's the accused. The accused can waive or invoke Miranda. They can do it expressly or they can do it implicitly, as long as they do it in a way that's not ambiguous. They can even waive them as long as they do it knowingly, intelligently, and voluntarily. They can invoke the right to counsel. Now, that's a summary of the controlling rule. Let's do the linking. Fox did not waive or invoke Miranda because they were never given to him. No point did he ask for counsel. This would be important here, but he didn't do any of it. And so what he did basically was talk voluntarily. And that, by the way, is not a violation of his Miranda rights. That is the analysis that I'm looking for, linking the facts to show us where the bones exist. And that person received max points, and I wanted you to see that. Final thing that I want us to see is this thing called the Next Gen Bar. This comes from the website for the Next Gen UBE, so you're welcome to go and browse further. This is Louisiana. We have not adopted Next Gen, so I'm not preparing you for Next Gen. However, I do want to say a few things to make you understand why I want this covered. Right now, I have a child who is licensed in a profession in one state. After working 2 years in that profession, my child decides that they want to go to another state and another profession. Guess what? That requires them to obtain a brand new license in a new state. So for all of the Louisiana takers who believe Louisiana may be home, it may come a day where you may have to go into another state and take that bar, which is Next Gen. So I wanted you to at least understand Next Gen. But the second thing I wanted you to think about is if you prepare for Next Gen, you're preparing for Louisiana. And it's a great way to start preparing because it is a very different kind of test. So our concluding discussion involves how Next Gen is structured. And then me recommending, of course, that as you prepare for this subject in Louisiana, you certainly can use this stuff to prepare because if you know how to do Next Gen, you're going to know Louisiana. So first thing I want you to see, notice what the site says as soon as you log on. The Next Gen exam will be first administered in a very limited number of jurisdictions in July 2026. This is relevant coverage because this is coming. I also want you to see here that there are a number of jurisdictions that have already decided that they're going to use Next Gen. So this map, which I got off the website, shows you all of the light blue colors. They have already adopted the Next Gen. I mean, that is majority of states. The gray has not decided or announced a decision. And then some of these are already administering, which we haven't gotten here. This is just to show you this diagram, how popular of an exam this has become and why I think you really do need to hear the words and understand what's on it because it is a trend and we don't know if Louisiana will go in the direction of these other states and join forces. So far, they haven't. As of July, I wanted you to see the states that are now officially in this Next Gen bar cycle. Then there's some more coming in July, some more coming in February. Look at the growing number of states who are gravitating toward Next Gen. Again, this is why I wanted us to have this conversation. So it is 3 hours each sitting. And every time that you sit, it's going to be done over the course of 1.5 days, then eventually 2 days. But when you show up, you have your own laptop, you're in person, and you're going to be getting a combination of different types of questions. So take a look. Some are going to be multiple choice. Some are going to be integrated question sets, which is new if you are only preparing for Louisiana. Some are going to be performance tests, which is new if you're only preparing for Louisiana. What content exists? So they say that what we're testing here is business association, civil procedure, con law, contracts law, criminal law, evidence, real property, and tort. So this subject is one of the subjects. But that's not it. They also test your ability to perform legal research, legal writing, issue spotting, investigation and evaluation. I hope you're reading this and remembering what you saw on Bloom's. Client counseling, advising clients, negotiating, disputing resolutions, relationship management. All of these skills are tested on this exam. So this is not just saying, give me a multiple choice or essay response. This is saying, go play lawyer. All right. Take a look again at the kinds of ways that they test on this particular exam. They show you for issue spotting how that's going to work, for the client counseling, how that works, legal research, how that works, legal writing, how it works. Just so you know, none of this is done without explanation. But ultimately, it's a practitioner's exam. When we get to this subject, I just wanted you to see what's covered for criminal procedure, search, reasonable suspicion, warrant. By the way, that's Fourth Amendment stuff. Confessions, that's Fifth Amendment stuff. Right to counsel, that's Sixth Amendment. This course is Fourth, Fifth, and Sixth Amendment, so I wanted you to see that you're essentially prepared for both. But this test is going to ask the questions in a different way. So let's talk about each of these. What they're asking you here is simply, if I give you a scenario, you can write me an essay and spot the issues and do an analysis. That's not new. You've been doing that on bar exams already. This stuff is new, C, B, C, and D, and that's what I want to mention. So this is basically saying, assume that you're the lawyer with the client and you have to really negotiate that kind of relationship. So I have to be able to apply now my professional responsibility, research. I'm going to give you several cases. I'm going to ask you to write a memo for C or D. I'm going to ask you to evaluate a motion to suppress. So that's your motions for criminal procedure. And how do they test now the criminal procedure skill of this motion to suppress, for example, because I'm asking you to write the memo on a motion to suppress. So this is I am a lawyer kind of test. I have to know how to write. I'm going to give you a case file, and you're going to have to be able to read the cases, write a memo, address issues. So this is not as simple as taking an essay exam or taking a multiple choice exam. This is a different kind of test, which means a different kind of learning. So I just wanted you to understand that before you get too deep in the course, that you should be preparing yourself for any bar. Doesn't matter what bar anybody gave you, doesn't matter what bar they come up with. You should know how to write, you should know how to research, you should know how to advise your client, you should know how to apply the law, you should know how to do Bloom's at the top 3 boxes. That's really what this is saying. And I just want to be sure that we all saw this and understood it, because the move now, of course, is to start testing in this way so that students know how to perform on a next gen, whether they're going to take it or not. So prepare yourself for success. Understand the things that you want. You have to be willing to put in the sweat equity to get them. This does not come easy, but once you get these skills, they are skills that will carry you for the rest of your life. The things that I've learned in law school in terms of how to do a legal analysis, how to write draft documents, I have used those skills all over the country now. I've used them to write encyclopedia entries. I've used them to write congressional statements. I've used them to write law review articles. I've used them to write books. I'm trying to help you understand the investment, the time that this takes for you to become a master and to become proficient at what this video is asking. I will not lie. It requires sacrifice. It requires you to push yourself to limits you didn't know you have. But once you get it, you become a commodity that can be marketed, and this is going to pay dividends. So you want to try to get this stuff down now. Do not wait till the end of a semester. Do not wait till the end of law school for you to start working on this. The time is now. You have to be serious right now about the kind of lawyer that you want to be. So I hope that this video helped you in all of these areas. Success in criminal procedure, success in law school, success on the bar, success in the practice of law. I hope that you walk away understanding that you have the sufficient skill, you have the sufficient support, The question is, are you willing to make the commitment to be a better version of yourself? Because nobody arrives in law school having this skill. This is something we work toward incrementally over the course of 3 years.